Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
I have no idea what Joey just said. All right. Recording live from FYP Studios, East and West, transmitting across the internet. This is episode 324. We're catching up to your age there, Larry.
It's going to be a while yet.
A while yet. All right. Well, this is Registry Matters, which is what I forgot to say. But how are you?
Doing awesome.
We are here again on a fine Saturday night, slightly later because you were upside down and you get dizzy or something like that.
I was definitely upside down for almost an hour today.
And this does not sit well with you?
Not at all. I might have vertigo.
Interesting. That doesn't affect you driving at all?
No, it only when I'm tilted back too far, when I get down flat or below vertical with my head.
All right. Well, we appreciate it if you would go over to your podcast app and leave a 5-star review, subscribe, like us, stars, all those things. Thumbs up, and it would be really great. And head over to Patreon if you feel generous, and you can become a part of our community. So you can download the show as just a podcast and listen to it on your drive to work. And that's a great way to do it. But Larry's never heard of a podcast before, and he's never downloaded one. So we're just going to put this on YouTube for the Larry kind of people. And for everyone else, you can do it as a podcast. What are we doing tonight?
Well, it's just you and me again. So you got...
I need like a sorrow track. I need
Mr. Gloom and Doom. And I did speak with Chance, and he's getting near being able to return in a not too distant future. But we plan to take a look at a case from the Court of Appeal in New York. And also, we're going to be doing a tease about an upcoming episode I'm working on regarding international travel.
Ooh.
And we don't have any articles because I want to get out of here. And I don't have any general rules for life either, so no entertainment tonight.
That's no fun at all. Gosh, you're just Mr. Doom and Gloom and no fun.
Well, I've got an important cat waiting for me to get home.
Oh, all right then. Well, tell me about this irate caller that talked about the right to travel from one state to another. And I mean, I guess since we have this case from New York, I think you could describe that call. As I recall, you said the person was upset because you appear to believe that a person should stay put in one state after they have been discharged from registration.
That is a pretty good summation of the phone call, and it's one of our loyal patrons, and so it wasn't really irate, it's overstating it, but it is some disbelief that I can't understand, that people have needs to move, they have the right to move, and why is it that I'm constantly telling people to stay put? And the reason I do that is because of the pitfalls. But this supporter commented after the recent episode where we had talked about the wisdom of moving, I think, from California to Florida after it had been moved from registration in California. And the person insisted that I must not realize that a person's free to move from state to state, and can't understand why I'm not able to understand that people have that right to relocate to other states after they've been removed from the registry. I assure you, I understand that right. You have to move, to relocate. You have the right to travel internationally. You have the right to do all these things. But the pitfalls are significant. For example, since the removal is not binding in another state, you may find yourself welcomed back into registration status as you get to another
Particularly
state.
in Florida.
Particularly in Florida. And in Florida, you're going to have the additional pitfall of they won't remove you from the website, even if you do leave the state again. If they put you back on the registry and you decide it's not all it's cracked up to be and you leave Florida, the vestiges of that registration will still be there. So that's what I do understand. And if the vestiges of being on the registry is as bad as what people say they are, and I believe they certainly could be detrimental, Why would you want to put yourself in that position? That's the question I ask.
Just for context, if I'm the way that the person that released me from the registry, when whatever, the handler, the sheriff there, he told me that be careful what states I travel to or move to, and if I end up on their registry, if I were to move back to Georgia, then I would have to register. If I don't have to register in another state and I move back to Georgia, I don't have to register. Did I word that clearly enough?
That is quite interesting. I don't think you've ever shared that with me. If you were to move to a state that forced you to register and you went back to Georgia, you would be entering Georgia as a registered person, but you would also
Yes.
be entering Georgia as a person who had been terminated from the duty to register. It would seem to me
Correct.
like the Georgia Superior Court order would supersede the fact that you relocated to Georgia. That would be quite an interesting thing.
Yeah, but so like if you go to some shitty place like Alabama or Mississippi or whatever, and they're gonna put you back on the registry. You're like, oh, you know what? So I ended up on their registry and I moved back to Georgia. Now you're on Georgia's registry. Like, wow. So back to the thing you don't understand that I keep saying in quotes. That's why you should stay put. If you got off the registry where you are, stay where you are.
If you can. Now that there are some people that have dying parents and they have employment that's too compelling to resist and they have to relocate. But that would be something that I would try to avoid, because as the law is currently constructed, it's 50 states determining who's covered, and they can determine that you're covered even though another state has determined that you're not. And that's the pitfall of moving after being dutifully discharged by whatever the process is. In your case, it was a court determination. In some cases, it's merely passage of time. But in either instance, after you've been dutifully discharged, why would you want to subject yourself to that again?
Without a doubt. Without a doubt. Just like the person that we've covered that moved to North Carolina that knocked on the registration people's door multiple times, saying, are you sure I don't have to register? Are you sure? And then they went and found him. You sure do.
Yeah, no, that was funny. I do remember that.
So do you want to cover why you can't understand this individual?
Well, what do you mean? I think I understand it, but I don't understand why it's complicated. If you don't mind being subject to registration again, move all you want to.
Sure. And Larry, it's just a website.
Well,
why can't you get that through your head?
But I'm being told that it's the same thing as being required to register. For example, we've had many people say that I'm oblivious to that point. But if it's only a website, you still wouldn't want to be on that website if you didn't have to be. I wouldn't think.
I would definitely not want to be on that website. Definitely not for all of my days that are left.
So, all righty. Well, hopefully that clarifies it. But yes, you do indeed have a right to move. But I don't advise it unless it's a must.
Well, let's head over to the main event. We are circling back on the case we discussed in episode 238, which is like 2 years ago now, huh? On September 17th of 2022. Do you remember the episode?
Not word for word, but the FYP archives remember it word for word, and I went back to our archives.
Well, I remember it word for word. I remember every little detail of the things that we covered on that particular episode. The case is the people of the state of New York versus Matthew Corr, and that's Corr. We discussed the decision from the Appellate Division of the Supreme Court of New York, Second Department. Now that there has been a decision from the state's highest tribunal, the Court of Appeal, what is the issue here now?
It's essentially the same thing because the losing parties appealed. It has to do with the clock restarting when a registrant moves to New York. The challengers asserted the time when another state's register should be counted in New York. While the statute requires some PFRs to register for life, those in the lowest risk category register for a term of 20 years. And New York does use a risk-based system rather than a tier system. The issue here is whether the statute entitles PFRs who are classified as the lowest risk category upon relocating to New York to receive credit for their time registered under the laws of other states. That's the issue here.
Do you mind if I go through and set up what's going on?
Well, sure, go for it.
All right. In each of these appeals, the person was convicted in another state of an offense that required him to register under the laws of that state. Some years later, each PFR relocated to the state of New York and was required to register as a level 1 risk under SORA, which is the Sex Offender Registration Act. Did I get that right?
Correct.
Okay. Neither of them is designated a sexual predator, sexually violent offender, or a predicate PFR. What the heck is a predicated PFR?
I have no idea. We need to have Charles here to explain that.
During the risk level determination hearings, each PFR requested that the Supreme Court order him registered nunc pro tunc to the date when he registered as a PFR in the state where he was convicted of his sex offense. In effect, giving him credit for the time registered in the foreign jurisdiction against the 20-year registration period. The courts denied the request, and the appellate division affirmed in 2 cases that I'm not going to cite here because it's really long, but you can look up People versus CORR. People versus McDonald. And so how's that?
Fantastic. Not sure I'm even needed this evening.
Probably not.
But the duration of registration and verification for offenders classified under SORA as level 1 risk, other than those designated as sexually predator or sexually violent offender or whatever predicate sexual offender is, those are registered annually for a period of 20 years from the initial date of registration. The PFRs argued in this case of an out-of-state PFR, the phrase initial date of registration plainly and obviously refers to the date the offender initially registered in the state of conviction, as opposed to the date of subsequent registration in New York. New York responded that SORA's use of the phrase initial date of registration refers to the date when an offender first registers under SORA in New York. The court noted, although defendants also raised constitutional challenges, those challenges are not preserved for our review and we therefore lack jurisdiction to entertain them.
And what were those other constitutional issues?
I suspect, I didn't see it in the opinion, but I suspect they were challenging the constitutionality of the registry being imposing punishment or whatnot, but I didn't see those claims in there, so I don't know.
Well, the court stated the issue before us is purely one of statutory interpretation, and we apply our well-established rules to determine legislative intent. Where the language of a statute is clear and unambiguous, courts must give effect to its plain meaning. Is the language clear here?
Yeah, well, it depends on one's perspective. The court stated, we start this statutory text guided by principles that statutes must be construed as a whole and its various sections must be considered together with reference to each other. And that's what you hear me talk about, read in harmony. You remember I say that, you have to harmonize what you're reading. You can't just pick and choose, because within the Sex Offender Registration Act, there may be 2 similar provisions that may not exactly match. So you have to look at all. But anyway, repeatedly, relatedly, absent any indication or intention to the contrary, where the same word or phrase is used in different parts of a statute, it is well presumed to be used in the same sense throughout, and the same meaning will be attached to similar expressions of the same related statute. So reduced and simplified, that means wherever that phrase initial registration is used throughout the PFR registration statute, they're going to look at how it was constructed there and what it likely meant there, and they're going to construe this all together. And I think they determined that the language meant based on their rules. I think they determined what the language meant based on their rules for statutory interpretation, which is they look and they harmonize everything, and they came up with what they think it means.
They stated, courts cannot amend a statute by inserting words that are not there nor will a court read into a statute a provision which the legislature did not see fit to enact. This does not sound positive to me. Can you clarify the issue again?
Sure. The issue that's being clarified by the court is the meaning of the phrase initial date of registration. That's the issue that they were deciding, and unfortunately the decision was not favorable for us.
Now, can you admit that this is screwed up for us?
No, I cannot admit that. So the court stated the meaning of the phrase initial date of registration cannot be discerned by reading Correction Law 168H subsection 1 in isolation, and therefore we look to its use in other sections of SORA for guidance. Construing the statute as a whole, as we must, we conclude that the phrase initial date of registration refers to the date when an offender first registers under SORA, meaning in New York. They came to that conclusion by reading the statute in harmony with other sections of law. They noted the durational requirements in Correction Law 168H subsection 1 are explicitly tied to the annual verification requirements which are set forth in the preceding section of SORA. Specifically, Correction Law 168F subsection 2 sets forth obligations that a registrant is required to fulfill by reference to the initial registration date.
You know, Larry, I'm pretty sure that you're really, really stubborn. Why can't you see that PFRs who have been registered in another jurisdiction should be given credit for that time?
Oh, I'm not that stubborn. I can agree that they should be. Unfortunately, the people of New York chose not to provide that credit. If the court chose to insert language that is in the statute, wouldn't that be legislating from the bench? And we can't have that, can we?
Certainly not. For the language, initial registration would have to mean that the first time a person ever registered. What you're saying is about as absurd as saying that a person who was first licensed to drive in Georgia at the age of 16 should be required to take all tests again in New York because they've not been initially licensed in New York.
Well, I'm not actually saying that. The court said it. They stated the phrase initial registration date expressly references the offender's registration under SORA. They went on to point out that, quote, our dissenting colleagues appear to agree that the phrase initial registration date in section 168F subsection 2 refers to the first time offender registers after an offender is subject to New York SORA. We understand the statute's subsequent use of materially identical phrase initial date of registration to have the same meaning. Considering the two interconnected provisions together, we conclude that the initial date of registration refers to the date when the offender first registers under SORA, not the date the offender is required to register in the laws of another jurisdiction. It's the court saying it. I disagree with it, but I do respect what the court has done.
You're never a fan of dealing with the dissenting judge's opinions. Can we talk about it in this case?
Sure, because there were some dissents here. Certainly, but they lost. The majority stated in reaching their conclusion that the initial date of registration refers to a date an offender registers in the state of conviction, our dissenting colleagues read Correction Law 168H subsection 1 in isolation. But our well-established rules of statutory construction do not require or even permit us to read disputed statutory provisions in isolation. Remember, harmony. To the contrary, a statutory provision that appears plain on its face may yet be ambiguous when read within the whole of the statute in which it appears. That's what I've been preaching here for 323 episodes.
Now, I don't see how you can say this and speak one side of your mouth and then the other side of the mouth and keep a straight face. This is absurd. Just admit it.
Can't do that. The court was very eloquent. They stated, setting aside our dissenting colleagues' context-free interpretation of initial date of registration, nothing in SORA provides or even arguably suggests that the legislature intended for an offender's registration in another state to have any effect on the conditions of registration in New York. The legislature didn't say that.
I see that. They stated, nowhere is this absent more than glaring in the Correction Law 168K, registration for change of address from another state. which contains detailed procedures for the registration, classification, and designation of a PFR who relocates to New York from another state or jurisdiction, all without reference to the offender's registration, if any, in the jurisdiction where the offender previously resided.
They said that, and beyond that, Section 168K does not create procedures for the SORA court to establish the offender's registration in the state of conviction, to order the offender's registered nunc-pro-tunc to the date, nor afford the offender credit for time spent on registries in other jurisdictions. The court stated, quote, surely, if the legislature intended for the phrase initial date of registration to require the SORA court to do any of these things, there would be some indication of this in the section. I tend to agree with that. If the PFRs had been present when this was drafted, they could have pointed out that credit wasn't provided, but I'm sure they were on the sidelines, as they typically are.
Doesn't the federal AWA, which is the Adam Walsh Act, permit the state to recognize credit for time on another state's registry?
Yes, it does, but it's not required. And the court recognized that. The court stated the guidance notes, and they're talking about the AWA guidance from the SMART office, that states are free to choose to give a registrant credit for a portion of the registration period that has run in another state. But it does not mandate they do so. And SORA simply does not contain such a provision for assessing whether to award credit. And the court says we have no authority to amend SORA to create one. Defendants' reliance, and that's the challengers, on the Adam Walsh Act of 2006, which replaced the Jacob Wettling Act, is also unavailing, they said. Although defendants correctly note that the phrase initial registration as used in the Adam Walsh Act refers to offender's registration in state of conviction prior to release from prison, or if the offender was not sentenced to prison upon sentencing, the operative language in SORA predates the Adam Walsh Act by over a decade. So they're making it clear that obviously their language is older. The Adam Walsh Act came about a decade later, and the use of phrase of initial registration as appears in the Adam Walsh Act thus has no bearing on the intent of the legislature, because they couldn't have known that the Adam Walsh Act was coming 10 years before when they wrote this legislation. So they did not find that very persuasive.
I'm going to try and ask you the same question, but yet in a different way. Can't you see that this is a complete waste of resources?
I can see that, and so did the court. They stated, quote, we recognize that the statute as written may lead to unfair results in some circumstances. For example, an offender with a minimal risk of reoffense who has spent a substantial time compliant with an effectively administered out-of-state registry scheme without having reoffended would seem to deserve credit for the time as a matter of policy. Moreover, the diversion of public resources and attention towards offenders such as those arguably undermines the state's effort to protect the public against genuinely dangerous offenders. They recognize that. On the other hand, they noted that not all state registry schemes are necessarily created equal, for example, in terms of supervision and registration requirements. And there's no specific mechanism under New York SORA for a court to determine whether a foreign state's administration of its registry is as exacting as New York's, or to the extent to which a particular offender complied with his or her obligations under that state statute and remained free of reoffense. Can you at least admit that that's logical?
I guess I can agree that that's logical.
But we
so
don't.
You agree that this? What? Go ahead.
We don't agree. We don't agree with the outcome, but you can agree that you can see how they got there.
I suppose. So you agree that this is wrong, but as usual, you're stubborn against doing anything about it. Also.
No, that's not completely true. I'm not against the judiciary. I am against the judiciary usurping or overstepping their role in our process. I mean, we have a separation of powers, and we elect senators and representatives and governors, and those are where we formulate public policy. And I remember a court back in 1973 that declared that a woman had a right to control her own body and to exercise certain decisions related to her body. And people didn't agree with that because it was legislating from the bench. That was never enacted by the people. Right?
Absolutely.
So what I'm saying is that I'm going to try to be intellectually honest. If I don't believe that we should be legislating from the bench, And I would shudder to think that legislating from the bench is the most effective way to legislate. So I'm trying to be consistent. But the court noted that the interpretation of the statute adopted by our dissenting colleagues goes even further than to award credit for time spent registered under the laws of another state. An offender who completes a required 10-year registration period in another state and then, after a period of several more years, moves to New York would receive credit for all those unregistered years. This is because SORA requires offenders to register for 20 years measured from a certain date. I can see their logic there, because if they adopted the initial date of registration and you registered in Vermont for 10 years and you got released from Vermont, you would have been subject to no tracking for 10 years. So you moved to New York on 20 years, and the first date, one day after that, you would get credit under that theory for those from the date of initial registration. And they went on to say, we and our dissenting colleagues disagree only about the date from which the registration period is measured. If the operative date is the date of registration in the state of conviction, as argued, then our state has no statutory authority after 20 years have elapsed from the date to require registration, even if the offender who has not consistently did not register during the 20-year required period. So you can see some logic in that.
Now, I don't think I've ever heard of a state that does provide the credit, but some others do. The decision recognizes that. They stated other states opting to provide credit have set forth guidelines for when credit should be awarded and have delegated rulemaking authority to the relevant agency. Under the law of Maine, for example, a PFR subject to a 10-year registration period may apply to the State Bureau of Identification for day-to-day credit for time actually registered pursuant to a PFR registration statute in another jurisdiction, and the Bureau may grant credit if the registrant provides sufficient documentation in accordance with the rules adopted by the Bureau. New York could do that?
They could, if they had the authority. And the court noted that the Board of Examiners of PFRs does not currently have this authority among the expressly delegated powers. Now, I know I've been hearing our people pontificate for years about how the delegation of powers, this delegation authority. Now, if they have not been delegated this authority, are you all of a sudden wanting them to invent authority that they don't have and do something that they've not been delegated the authority? I mean, that seems to be inconsistent with being against delegation, does it not?
It does. Wait, that's a hard way to answer. It does not, Larry. I agree.
So, but it's of course a fundamental principle of administrative law that agencies are possessed only of those powers expressly delegated by the legislature, together with those powers required by necessary implication. Now, I have a little bit of consternation with that required by necessary implication, because that is broadening out. My position is you have only the powers that were delegated to you by the legislature. So if they pass a law and they say you will pay disability benefits to people who meet this definition of disability, they don't have anything else to do beyond that. So if there's a PFR law passed that says people will register for 10 years, the administrative agency can't say, well, in our judgment, we think they should register for 15. But they went on to say it's for the legislature to make these policy determinations and pass the relevant law and delegate any rulemaking authority.
Now, I noticed at the end of the majority opinion, the court stated, finally, this is not the only provision in SORA that tests out-of-state PFRs differently than it treats in-state PFRs. Citing Taludo, and that's 39 New York 3rd at 314, in Taludo, we recognize that correction law in 160A subsection 3 paragraph B or something like that requires any person subject to SORA's foreign registration requirements to be designated a violent offender, regardless of whether the underlying offense is violent in nature. The result of the defendant in that case was no less absurd than the hypothetical circumstances outlined in Judge Rivera's dissent. While recognizing that this requirement, based on SORA's plain text, may well, that's in quotes, may well, have resulted from a quote-unquote legislative drafting error, we unanimously conclude that we were without the power to write the statute. From that, you can see Toledo 39 3rd New York at 314 and 315. The same rule applies here.
And they concluded, accordingly, in each case, the order of the appellate division should be affirmed without cost. So here we are, 2+ years later, and this unfortunately didn't make it to my table as soon as it came out in late June. But now I'm aware of it, so we're following up, and now we know that if you go to New York, you will receive no credit for time registered. So again, this is Larry's advice to you for what it's worth. If you've been registering in another state and you've got a long period in and you're within the horizon of being able to get off, it doesn't seem to make a lot of sense to go to New York because you're going to start from scratch.
You don't happen to know other states offhand that do give you credit for time, do you? I've seriously never heard of a state that I've never heard this we've never brought this conversation up that I'm aware of.
Other than Maine, I've not heard of a state, but I was aware that Maine does it. There's a process established in Maine. So yes,
damn liberal, pointy-headed do-gooders.
And it may be the case in Vermont, but I'm not sure. I know that our Vermont listener will tell us if it's there, but I think it might be.
He's not here.
So all right,
interesting. Huh. So you could do all of your time in a crap state and then move to another state and they would count that time and perhaps get off in another month or another year or something like that.
Well, I noticed when you were reading that it said may and it didn't say shall. Now that's going to be funny if you can get into a situation where you've done the registration and you verified it. They say, well, the law says may, we're not required to. Now, wouldn't that be funny?
That would be. So do me a favor. Would you quickly describe, like, I realize that these are very simple, common words that mother may I kind of things. Like it's just a simple word, but legally, what's the difference between the two terms?
A huge difference because may leaves discretionary possibilities of having one outcome or another. When it says that conditions of release shall be set within 24 hours of a person's arrest, that means that somehow or another, whether it be by a judicial official or by an administrative person sitting at the jail, that person must have their conditions of release set. Or it may say that they shall be taken before a judge within 72 hours, and that means that it's not optional. And when it says may, there's leeway there.
The other thing, this has come up a handful of times, and I'm trying to find it. The nunc pro tunc. What is that again?
Well, you're basically pretending that something that didn't happen happened at the time. So if you, like we talked at a conference, forget which one recently, about a person getting off the PFR registry and their registration date, the rules changed after their date of conviction. And I suggested, well, what option might be considered to do, if you can get the prosecution to agree, would be to change the sentencing date, issue a brand new J&S, the judgment sentence, nunc pro tunc. So you would just backdate it it would be done now, but it would be dated for back then. So these people were asking that their date of registration in New York be established nunc pro tunc for the date they first registered in whatever states they were from. So
okay.
It's just a little bit of voodoo that we do, because if you mess up with something in court and need to correct it, oftentimes the easiest way is with an order nunc pro tunc if everybody agrees.
All right then. And for spelling, that's NUNC PROTUNC?
I believe that's correct.
I will look for it because there's no way that our transcriptionist people are going to get it. It's NUNC PROTUNC. Okay.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
So we will move over to a little bit of a teaser for what we're going to cover in a future episode. And that's you want to talk about some international travel since you are the world traveler yourself. But so what inspired you to do this?
Well, one of our supporters has done what few have ever done. He provided me with solid evidence that his fears are not driven by an imaginary boogeyman, that they are in fact real fears.
Say that again, though.
He provided me with solid, credible evidence that his fears are not driven by an imaginary boogeyman, but they are in fact real and justifiable fears.
Real boogeyman?
Yeah, it's not an imaginary boogeyman. At least one of his fears. His concern is that he plans to leave his current state of residence and never return to the United States. His registration officer told him if he does not plan to return, they will not process his notice of international travel. They say that travel has to contemplate a return trip, and since he's not planning to return, he's not traveling per their interpretation of the law. Now, can you at least concede that this is funny, that one-way travel is not really travel?
I see. That's not funny. That's interesting that if we all said that we were taking one-way trips, then they would never tell the smart office or whatever that thing's called, right?
Well, what's even funnier is that they told him that they would, once he declares that he's leaving the country for good, that they will deregister him. And I said, well, it seems like to me that that's weird because they're going to deregister you before you leave. That doesn't close the loop on recognizing that you made it someplace. I said, it seems like to me that that would make it possible for you to navigate the United States unregistered until they apprehend you, till you get stumbled into a traffic stop and they run you or something happens that you come to their attention. But it seems like to me that would be you'd be able to exempt yourself from registration. And I said, that seems relatively bizarre that they would do that. But he said that that's what they've insisted on multiple contacts, that they will deregister him and they will not report his travel because he's not traveling, he's relocating. And so I continue to think that it's funny.
But all right, so let's just I'm confused. So wouldn't one have to travel to leave the United States even if they do not plan to return?
Well, I think it would. Wouldn't that be considered travel?
If you leave from Indiana, you are in the United States traveling. I don't see how you would get around. I don't see how where that logic would come in. That seems like you would be traveling in the United States, whether you plan to return or not. Who cares?
Yeah, and that's the reason why it's funny to me.
Well, I guess we are only teasing this without going too far into the details. What proof did he provide?
He provided an affidavit for the man's arrest that was filed in the federal court system. And more importantly, he provided proof that a person was pulled off a plane that was about to depart the United States. And I had always arrogantly said that those are imaginary rumors that people are spreading that are wanting to fearmonger. And that is not what has happened, at least in one instance.
Paragraph 3 states, the facts set forth in this affidavit are based upon my personal observations, my training and experience, and information obtained from various law enforcement personnel and witnesses. This affidavit is intended to show merely that there is sufficient probable cause for the requested criminal complaint and search warrant and does not purport to set forth all of my knowledge of or investigation into this matter. Did they get the warrant?
Yes, it appears they did. And the affidavit states, on November 13th, 2012, Sanchez was convicted in the Superior Court of the State of California, County of Ventura, of lewd act upon a child in violation of California, blah, blah, blah. As a result of the conviction, Sanchez is permanently required to register as a PFR under SORNA and to provide the government with advance notice of any foreign travel. On September 30th, 2020, without providing notice of foreign travel, Sanchez attempted to fly from Los Angeles, California to Cairo, Egypt. Specifically, Sanchez was ticketed to fly from Los Angeles, California to Paris, France, change planes, and then fly to Cairo, Egypt. Sanchez boarded the flight to Paris, France, at Los Angeles International Airport, but was detained before the flight departed.
Do you think that are we going to be able to have any guests to discuss this?
I think we've got one for sure, and possibly a second guest in the offing that's being worked on. So yes, I'm hoping that we have quite an elaborate presentation on this, because as an entity, we do not want to mislead people, unlike dozens, if not hundreds, maybe even thousands of YouTubers that want to instill fear. We want to provide information that's reasonably accurate. And now I have learned that a person at least once was removed from an airplane, and I did not believe it until I saw it. Now that I saw it, we need to share this with people because it has happened at least once. And doesn't that increase the odds that it could happen again?
That seems reasonable, unless they were wrong.
Well, so therefore, I want to get a little bit deeper into this, and that it's very unique of the circumstances of wanting to leave the country, because leaving the country for a visitation is one thing, but leaving permanently is something that far fewer people would contemplate doing. And if you don't do it right, let's just say that he's done all of his homework and he follows the advice of the registry official in California, and they take him off the plane as he's about to depart. This would be very bad.
I would say so, especially after you've paid your whatever $3,000 for a plane ticket to go to these places, and then they snatch you off. And if you didn't get that travel insurance, and that might not cover you if you get snatched off the plane.
I would like to think there would probably be an exception for that. If you're wanted by the law, they probably wouldn't pay for you missing your flight because they would probably deem that your fault.
See, that's funny. Not funny, Larry.
That's not funny?
That's not funny. No.
So, but yes, so people, again, the same thing with the overstaying a visitation in a state. I continue to invite folks who believe that they're watching you, that if you stay 49 hours in a 48-hour state, or you stay 73 hours in a 72-hour state, if you can unearth evidence of a prosecution related to those circumstances, those very narrow circumstances, please provide it to us and we will dig into it and discuss it, because that information needs to be out in the public domain. And I'm not trying to hide it. I just don't want to make people fearful of imaginary boogeymen. And right now, I do not have any evidence that a prosecution has ever happened for a person who's overstayed a few hours on a visit that did not have the intention or had not established a permanent connection to that state. If you have the evidence, please submit it and we'll discuss it.
Do you happen to know if this individual is trying to keep their American citizenship?
I don't think that that's a high priority for this individual.
A question somebody asked in chat.
Yeah, I don't think that's a high priority. I think that the Kool-Aid has been consumed, and the U.S. is a horrible nation, and it's paradise in other nations, and this person wants to be out of the country. And I feel bad because I know that things are not ideal here, but I continue to question why millions are on waiting lists to come here. Probably I would guess without proof that more people are on waiting lists to come to the United States than any other nation on earth. That was my guess. Can you think of another nation that accepts immigrants that has a longer waiting list than we do?
It's almost hard to find a country that willingly accepts immigrants, let alone, you know?
So
I mean, I know they're out there, but like, my understanding is most countries don't have a lot of immigration allowances. And so we have a long waiting list. And we have a really screwed up immigration policy too. I
agree with that. But being that somebody who's been as dysfunctional in their life as my circumstances were, being that I made a decent life in a country for all the problems, better or worse, I believe that with dedication that almost anybody can do it. I really do. I believe that the opportunities are abound and abundant, and that a person can do well in the United States despite the challenges of being on the registry. And I encourage people to try to look for the best way to deal with what you're dealing with, which may be relocating. I don't tell people not to leave Florida. I don't tell people not to leave Louisiana. I tell people not to leave Vermont. I tell people not to leave the good states. But
other than it's cold.
So I don't tell people not to leave bad states, because the work that you would do to try to change the law in the really bad states would be insurmountable, and you would give up the rest of your life trying to make these changes. So if you're in Alabama with what do I call that? You got a little clip for me about governed by the. Play that one for us.
The governor, which
Reagan's clip about governed by the biggest.
Run by the strangest collection of misfits, Looney Tunes since the advent of the Third Reich.
That's what Alabama's governed by right now. And so
is that the right one?
That's the right one. And if you're in Alabama, you would spend the rest of your life trying to fix that place. So if you're in Alabama and you have the option to leave, I don't encourage you not to leave Alabama, because you have very little to lose. It's only going to get better.
Yeah, pretty much anywhere you go is going to be better.
So therefore, but I encourage you, if you're in a decent state, not to leave, because it could get far worse.
Sure. Totally. I'm with you on that.
So,
any parting words? I got a couple announcements.
Well, you've got an announcement, and I was going to make an announcement about those of our loyal supporters that have been so loyal and generous that if you are thinking about year-end planning because of tax benefits you might derive, FYP Education is a 501c3. So anything that you want to send in the way of year-end giving would be tax deductible.
Fantastic. So those what were they called? Stimulus checks, right?
Well, there hasn't been one since 2021, so I don't think many people are going to be passing those along. But it was a fantastic year for equity investors this year, past year, the year we're in. It's been a great year, and people that are starting to analyze their finances and saying, gee, I had a great year and I'm going to have a big tax liability. You can certainly diminish some of that by your year-end giving to your favorite 501c3. It doesn't have to be us, but certainly put us on the list of consideration. And I don't know.
You could think about us.
I don't know what you can provide in the way of linkage, but we do have a donate button on FYP website where you can just
fypeducation.org. It's right there. Just hit donate,
and you can specify your amount of year-end giving, and it'll be greatly appreciated. And we're trying to keep certain programs alive, in particular the podcast. The transcript is very expensive to produce in terms of what it costs to get that to the people who subscribe. So that would be one place where money would be useful, is for continue the transcription service for our small subscriber base. It's small, but still it's very useful to the number of people who look forward to receiving it.
I would have killed to get it if I could be in two places at the same time and be locked up and do the podcast. That would have been fabulous.
So, well, that's my announcement. What are your announcements?
Well, I wanted to make sure that I don't remember if I announced we had the new patron Scott, who subscribed back in November. I don't remember. And I said, well, I'm sorry if I missed you. So, but anyway, thank you for becoming a patron. And then in the last week, we've had Mike D as well as Jason C, and they have become patrons in the last week or so. And so thank you all very much. I can't thank the patrons who support the program enough. There aren't enough words for me to describe that they support us in what we do.
And some of them are extremely generous, and they even send us packages for special events. And thank you from Tennessee for the lovely fudge, particularly the peanut butter. I love that.
I didn't eat any of that. I ate the other fudge, and it was yummy. And also the gift card. That was, he's our number one patron, and then also sends us fudge.
It's amazing, and I appreciate the gift card as well.
Thank you very much. So head over to registrymatters.co for show notes. Leave voicemail at 747-227-4477, and email registrymatterscast@gmail.com. And as I said before, support us on Patreon, which is at patreon.com/registrymatters. And you can join us on the Discord server. Oh, one other thing, and I have it updated here in the show notes as well. We've got more t-shirts coming online. There's like some really funny ones out there. Particularly, Larry has said that if you will, he will pay for the shirt that says Kabuki Machine. If when it's time for your Kabuki Machine analysis, that you wear that shirt when you go see the Kabuki Machine operator, Larry will refund your money.
Absolutely. And I just want to see a photo of you sitting in the polygrapher's office taking a
Oh my
test.
God.
That's going to be fun.
Can you imagine? That would be epically funny, Larry. That would be one of the funniest things like ever. Oh, my screen switcher thing died. Crap. Oh well. All right. So head over to fypeducation.org/shop, and that would also help support the program if you want to get a sweatshirt or a tumbler or something like that. And we're going to bring more stuff like that online as well. So I hope you have a fantastic night. I hope you feel better, and we will catch up with you very soon. I will talk to you later.
Good night.
You've been listening to FYP.